I want to just welcome everyone back here this afternoon. I know there's been lots of activity in the House and still some going on across the street, I understand. But as Ms. Jennings said this morning, we've got a lot of hard work to do here on a bill, so we're going to get started. Pursuant to the order of reference of Friday, October 26th, the Legislative Committee on Bill C2 will now resume its study on the bill, and welcome Minister Nicholson here to make a presentation. We will hear his presentation, approximately 10 minutes, and then go to questioning. Thank you.
Thank you very much, Mr. Chairman. I'm pleased to be joined at the table on my right by Catherine Kane, the Acting Senior General Counsel, the Criminal Law Policy Section, and on my left, Douglas Hoover, Counsel, Criminal Law Policy Section. Mr. Chairman, I'm pleased to appear before your committee as it begins its review of Bill C2, the Tackling Violent Crime Act. This is the government's first piece of legislation in this session of Parliament, and the Tackling Violent Crime Act underscores our commitment to safeguard Canadians in their homes and on their streets and in their communities. It is a confidence measure, and Bill C2 reflects the depth of this unwavering commitment by the Government of Canada. Entente que mesures visant à accroître la confiance du public.
Besides, Canadians have lost confidence. As a confidence measure, Bill C2 reflects the depth of this unwavering commitment.
They want a justice system that has clear and strong laws that denounce and deter violent crime. They want a justice system that imposes penalties that adequately reflect the serious nature of these crimes and that rehabilitate offenders to prevent them from reoffending. Bill C2 seeks to restore Canadians' confidence in our system by restoring their safety and security in their communities. And this is, in fact, what is reflected in the preamble to Bill C2. The Tackling Violent Crime Act brings together 5 criminal law reform bills that we introduced in the previous session of Parliament. One of them, C10, imposed a higher mandatory minimum penalties of imprisonment for 8 specific offences involving the use of restricted or prohibited firearms or in connection with organized crime, and that of course includes gangs. It is also for offences that do not involve the actual use of a firearm, namely firearm trafficking or smuggling, or the illegal possession of a restricted or prohibited firearm with ammunition. The Tackling Violent Crime Act reintroduces the former Bill C10 as passed by the House of Commons. It also includes one of my favorites, and that's C22, that increases the age of consent for sexual activity from 14 to 16 years of age to protect young people against adult sexual predators. There is proposed, as you are, I'm sure, aware, a 5-year close-in age exception to prevent the criminalization of sexual activity between consenting teenagers. And the Tackling Violent Crime Act reintroduces Bill C-22 as passed by the House of Commons. It also includes C-32 that addressed impaired driving by proposing the legislative framework for the Drug Recognition Expert Program and requiring participation in roadside and drug recognition expert sobriety testing by simplifying the investigation and prosecution of impaired driving and by proposing procedural and sentencing changes, including creating the new offences of being over 80 and refusing to provide a breath sample where the person's operation of the vehicle has caused bodily harm or death. The Tackling Violent Crime Act reintroduces the former C-32 as amended and reported back from the Justice Committee. we also have Bill C-35 that imposes a reverse onus for bail for accused charged with any of 8 serious offenses committed with a firearm, with an indictable offense involving firearms or other regulated weapons if committed while under a weapons prohibition order, or with firearm trafficking or possession for the purpose of trafficking and firearm smuggling. And the Tackling Violent Crime reintroduces the former Bill C-35 as passed by the House of Commons. The Tackling Violent Crime Act also reintroduces reforms proposed by the former Bill C-27 addressing dangerous and repeat violent offenders with additional improvements. As I have noted, and with the exception of the dangerous offenders reforms, all of these reforms have been thoroughly debated, reviewed, and supported in the House of Commons. These reforms had not yet progressed, those included in C-27, to the same level of understanding and support in the previous session, and which now include additional improvements to address concerns that have been identified in the House of Commons, as well as by my provincial and territorial counterparts. So let me take a moment to go through these reforms. The Tackling Violent Crime Act retains all of the reforms previously proposed in C-27 regarding peace bonds, which has been well received within the House of Commons and beyond. Accordingly, Bill C-2 still proposes to double the maximum duration of these protective court orders from 1 to 2 years, and to clarify that the court can impose a broad range of conditions to ensure public safety, including curfews, electronic monitoring, treatment, and drug alcohol prohibitions. I believe that this particular provision will be well received across this country. Many people have complained for many years that by the time you get a 1-year peace bond, it's too short a period of time, and that 2 years would be much more appropriate in terms of getting the bond and having it put in place. Under this bill, as well as the former C-27, Crown prosecutors will still have to declare in open court whether or not they intend to bring a dangerous offender application where an individual is convicted for a third time of a serious offense. We have retained some procedural enhancements to the dangerous offenders procedures, allowing for more flexibility regarding the filing of the necessary psychiatric assessments. As with former C-27, an individual who is convicted of a third sufficiently violent or sexual offense is still presumed dangerous. C-2 also toughens the sentencing provision regarding whether a dangerous offender should receive an indeterminate or a less severe sentence. This amendment modifies C-27's approach to make the courts impose a sentence that ensures public safety. And finally, it includes a new provision that would allow a Crown prosecutor to apply for a second dangerous offender sentencing hearing in the specific instance where an individual is convicted of breaching a condition of their long-term supervision order. This second hearing targets individuals that were found by the original court to meet the dangerous offender criteria, but were nonetheless able to satisfy the court that they could be managed under the lesser long-term offender sentence. If they show by their conduct, once released into the community, that they are not manageable and are convicted of the offense of breaching a condition of their supervision order, they would now be subject to another dangerous offender sentence hearing. Importantly, This new proposal does not wait for the offender to commit yet another sexual assault or violent offense to bring the offender back for a second hearing for a dangerous offender sentence. Instead, it would be triggered simply by the offender failing to comply with the conditions of his release contained in his long-term supervision order. For example, for failing to return to his residence before curfew or for consuming alcohol or drugs. And of course, this second hearing would also be triggered if the offender in fact did commit a further sexual or violent offense after his release into the community. These new proposals directly respond to a serious problem identified by provincial and territorial attorneys general in recent months, and indeed some of these issues have been flagged since I think about 2003. Since 2003, the judgment by the Supreme Court of Canada in the Johnson case, many violent offenders who meet the dangerous offender criteria have nonetheless managed to escape its indeterminate sentence on the basis that they could be managed. That is, the risk of harm that they pose to the community could be successfully managed in the community under a long-term offender sentence. So we reviewed the dangerous offender cases since the 2003 case in Johnson and identified 74 such violent offenders. We then looked at how these individuals fared once they were released into the community. To date, 28 of these 74 dangerous offenders have been released into the community. Of these 28, over 60% were subsequently detained for breaching the conditions of their long-term supervision, and 10 were convicted of breaching a condition of their long-term supervision orders. C2 will prevent dangerous offenders from escaping the dangerous offender indeterminate sentence in the first place and will enable us to more effectively deal with those who nonetheless receive the long-term offender sentence but then demonstrate an inability to abide by the conditions of their long-term offender supervision order. Of course, I have carefully considered the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights in respect to the totality of these new dangerous offender reforms, and I am satisfied that they are fully constitutional. These measures have been carefully tailored to provide a prospective, targeted and balanced response to the real and pressing problem posed by these dangerous offenders. En résumé, Monsieur le Président, le loi...
To sum up, Mr. Chairman, the Tackling Violent Crime Act proposes reforms that have already been supported by the House of Commons.
Many have signalled an interest in supporting. I appreciate the collaborative spirit that this committee and members have shown thus far to enable the commencement of the review of Bill C2, and it is my hope, and that of all Canadians, that this collaboration will continue to enable expeditious passage of this bill. Thank you, Mr. Chair.
Thank you, Minister. We'll now start the rounds, and very similar to the process that we use in Standing Committee. The first round will be 7 minutes, and the following rounds will be 5. Madam Jennings.
Merci, Monsieur le Président, et merci beaucoup, Monsieur le Ministre.
Thank you, Mr. Chairman, and thank you, Minister, for your presentation. I'm just going to adjust the sound here. Mr. Minister, there are a few facts I'd like to put on the table before putting 2 questions, and I'll be quite quick.
In 2006, the Liberals made the first offer to fast-track a package of justice bills through the House. This included C9 as it had been amended, C18, which is the DNA identification, C19, street racing, C22, age of consent, which we now find as part of C2, C23 criminal procedure, and C26 payday loans. This offer effectively guaranteed the Conservative government a majority in the House to pass those pieces of legislation, including the one that is in C2, the age of consent, at that time. Had the government accepted the Liberal offer, C22, the age of consent, would have become the law before the end of 2006, and our children would no longer have been vulnerable to sexual predators. On March 14th, the Honourable Stéphane Dion, Leader of the Official Opposition, added C35 bail reform to the list of bills that the Liberal caucus was offering to the Conservative government to fast-track. Despite, again, this offer of majority support, it took the Conservatives until May 30th to actually move it up on the order paper so that it would get to committee. Finally, on March 21st, 2007, Liberals again attempted to use an Opposition Day motion that, if passed, would have immediately resulted in the passage at all stages of 4 justice bills: C18, DNA identification; C22, age of consent, which is a bill that we see again before the House in your tackling crime bill C2, C23, criminal procedure, and C35, bail reform. Incredibly, the Conservative House Leader raised a procedural point of order to block the motion. In other words, the Conservatives have in fact fought the Liberals' attempts 3 times to pass justice bills, including the one that's incorporated in C2. Now, I notice that in C2, the section that deals with the dangerous offender, that some amendments have been brought forward. 2 category of amendments. One which deals with the long-term offenders. Breach of supervision orders, for instance, could trigger a new dangerous offender hearing in order to make them liable to the kind of sentences that dangerous offenders can be liable to. And if you studied, Minister, if you studied the transcripts of the House committee that studied C27, was in the process of studying it last spring before the prorogation of the House, Liberals actually made proposals for the very kind of amendments that we now find in the C27 section of C2, and received support from the Canadian Police Association, Mr. Tony Canavino, and from other witnesses who appeared who thought that it was a great idea and that it was something that would actually strengthen C27 and make the system more effective. So I'm pleased that the government listened. However, we also made another proposal, which was that right now the Crown continues to enjoy discretionary authority as to whether or not an application for remand and assessment for a dangerous offender designation will actually be made. And so your reverse presumption only will operate and become effective if the Crown makes that application. Liberals had been proposing that a 3rd conviction automatically trigger a dangerous offender hearing. That would then allow every single offender who's been convicted 3 times of the type of crimes that can lead to a dangerous offender hearing would actually be called before such a hearing, would actually be assessed and evaluated. May I ask why the government has decided in its wisdom not to go forward with an automatic trigger rather than a reverse presumption, which will possibly never or very rarely be put into effect because the Crown retains the discretionary authority to make the application or not? I'm finished.
Okay. Thank you very much.
I may have other questions, but that would have to wait for another day.
Or you maybe get Mr. Lee to ask him. I mean,
no, Mr. Lee has his own questions, and they're substantive.
Okay, thank you. You covered a lot of ground, Madam Jennings, and one of the things that you said is that Canadian children weren't as well protected from sexual predators than if the age of consent bill had been passed. I agree with you. I wish it had been passed. I was very disappointed that the Senate went home and didn't pass that. And when I was asked this question, I told them, I said, Canadian children aren't as well protected as they should be if that bill had been passed. I agree it should have been passed. Now, with respect to the offer, the fast tracking, I know this came in the form of a
I'd just like to excuse.
I'm sorry,
may I interrupt one
I'm sorry,
moment,
I thought
please?
you were done, but you please go right ahead.
May I thank you very much.
You've got about 40
Do
seconds
you mean
left.
that you wished it had been passed October 26, 2006, when the Liberals offered the Conservative government a formal offer to fast-track C-22, age of consent?
All right, thank you. If I could continue, you indicated as part of your question that on a couple of occasions the Liberal Party proposed in one case or a couple of cases motions and then on an opposition day to fast-track a number of justice bills. The problem with that, as I'm sure your House Leader and others could confirm, is that it was procedurally out of order. It was confirmed by the Speaker of the House to be procedurally out of order, and it didn't have the support of the NDP and the Bloc Québécois. So that was a bit of a problem in terms of trying to move this forward. But nonetheless, I'm looking for support for this legislation anywhere I can get it for any of these particular issues. And again, we have that.
Minister, we've come up to time, so we'll just have to. Monsieur Menard.
Alors, Monsieur le Ministre, bonjour.
Well, good afternoon, Mr. Minister. Good afternoon to your officials. I have 3 questions, if you will allow. The first is just how, and please understand that this deals with C-27, says it is the part of the bill that gives us most problems. How can it be compared with legislation in effect in the United States? Because there are 25 states and the federal government that have designations for what they call the 3 strikes you're out. I would like you to draw parallels. As you know, we had access in the committee to literature which was hardly convincing with regard to the legislation in the United States. I'd also like you to explain what's wrong with the present regime. Is it the onus is too high, the onus of proof? Is it that the Crown is not making proper use of available legislation? Because we found that the court was not using everything it had at its disposal in the criminal code dealing with dangerous offenders. I'd also like to come back to a question that Madame Jennings touched on, but although she couldn't get to the end of it because of time. When someone is made a dangerous offender, then there is an obligation to use certain provisions of the law. So there are 3 questions, and for the Minister, please.
I'm not sure, Monsieur Menard, I caught all of what the third one was. You said there are provisions in the criminal code.
Est-ce qu'il y a une obligation?
Sorry.
Est-ce qu'il y a une obligation de la part?
Is there an obligation on the part of the prosecutor? Because it seems to me that there's an obligation, but it seems here that there will be a new obligation under 27 concerning dangerous offenders.
I think I've got it. Thank you, Mr. Chair. In your first question, Mr. Menard, you talked about how is this different than American legislation. All legislation in the United States, of course, is not the same. They have the criminal law power is part of each state. You may be referring to what is usually referred to as a law in the state of California that has some, again, I'm not an expert on California law, but automatic convictions or rather automatic sentence provisions for individuals who are committed or have been convicted of 3 crimes. Now, what we have in Canada is what is known as a rebuttable presumption. If an individual has been convicted of the 3 types of crimes that I indicated in my opening statements, then there is an onus on the Crown to direct the court's attention to whether the Crown will proceed with a dangerous offender application. The onus would shift to the individual to demonstrate, and it's a rebuttable presumption, and that individual would have all the safeguards that are built into the Canadian system. They can bring evidence to show that they cannot or should not be designated a dangerous offender. So to that extent, there's nothing automatic about it. There, of course, would be a hearing that would determine this, but again, the individual could rebut that presumption. What are the problems with the dangerous offenders law as it stands? I think there was some need for clarification after the R.V. Johnson decision in 2003 to clarify some of the procedures and the criteria with respect to dangerous offenders. You made reference to Madam Jennings' comments about some of the issues that arise from an individual who has been designated a dangerous offender but nonetheless receives a long-term offender sentence, that there have been some problems. She identified a couple of groups that have indicated that there were problems in that area. In addition, I can tell you there are provincial attorneys general who believe that there should be some resolution, some clarification on that. And so I think there are a number of problems with them, a couple of which I've just mentioned to you. Sorry, you have another question?
Soyez plus explicite là.
Could you be a bit more explicit, please? Looking at the present system, because someone can be designated a dangerous offender, and we understand the difference between, we understand what this means. It means that they've committed a dangerous crime and that they have to be controlled adequately. Why are you putting forward this bill? Are Crown attorneys not using the present provisions? There were 324 dangerous offenders in the prison population. What are the problems, or 384 rather? What are the problems? Because are the present provisions being challenged? I'm trying to understand, is that because the onus is too high, the onus of proof is too high? Is it that there are, what exactly is it that you want to correct in the present legislation?
Well, one of them is just what I indicated. There are those individuals who we believe there is a problem, that if they get a dangerous offenders designation and then they are subsequently either released into the public and they then don't comply, the way the law is set up, it becomes very difficult. They basically have to start all over again. And as you may know, this is a very time-consuming, difficult, expensive operation for which Crown's attorneys are sometimes reluctant to pursue. So that very much is a concern that I believe is being addressed, and that is one of the reasons why in C27, with respect to the Johnson case, I'm sure you're familiar with, we've actually, since that time, we've actually seen a reduction in the number of attempts to designate individuals dangerous offenders, and that reduction, I believe, is a direct result of the Johnson decision. And so we are attempting to clarify that as well, and I think that would be, I think, helpful, and I think will be welcomed by Crown's attorney. Now, Mr. Hoover, I believe, has some else that he might be able to add if we're out of time on this.
Minister,
okay,
he may have something to add, but Mr. Hoover may have to do that in the next opportunity. Mr. Menard's time is up. Mr. Kilmartin.
Mr. Chair. Am I on? Mr. Chair, on the basis that we don't want to delay this, and we've heard from the minister, including even on the one amendment that they made to that part of the bill that C2 that was the old C27, I'll pass. Even though, Mr. Minister, I always enjoy having you here. Thank you.
You know, if I might say, Mr. Comartin, I always enjoy listening to you, and even from the comfort of my own home in Niagara Falls, I did hear your comments with respect to this bill, and I've listened to you on a number of occasions, and I think your comments, as usual, are helpful, and I appreciate hearing them.
Thank you, Mr. Minister. Mr. Harris, 7 minutes.
Thank you, Mr. Chair. Mr. Minister, thank you for coming today, and I want to say that the Bill C2, upon study, is a bold bill. It has substantive changes to the criminal code, and one that I'm sure is going to be appreciated by Canadians that have been looking for an extra measure of safety for themselves and their families. It does have some very bold moves, and it's tough on violent crime. History will show that in many cases when a bill such as this has come up for legislation or has even passed through legislation, and it's been decades since anything like this has come along, the constitutional challenge people are just rubbing their hands together waiting to get at it. And so I guess my question is that so that Canadians can avoid being disappointed about any hitches that might be in this bill, what assurances can you give us, Minister, that all of the due diligence has been done to enable Bill C2 to withstand any possible constitutional challenges?
I appreciate your comments, Mr. Harris, and quite frankly, I appreciate you sitting on this committee. You're not a regular member, I know, of the Justice Committee, and to you and your colleagues who are prepared to give your time and efforts to get legislation like this through, it is much appreciated. The drafting of these pieces of legislation undergo considerable scrutiny. It's incumbent upon me as Minister of Justice to confirm in my own mind that the bill, first of all, meets the test set out by the Canadian Bill of Rights. That's an obligation that rests on the Justice Minister for every piece of legislation that is tabled in the House of Commons. In addition, the Department is very careful in terms of making sure that legislation, to the extent possible, to the extent that we are able to predict these things, will withstand a challenge under the Charter of Rights and Freedoms. Now, that being said, it is the right of individuals who are charged with offences in this country. It's their right on their behalf or with their solicitor to file the applications to have these measures tested, and that's a function that has been around in Canada for, I guess, since 1960. With the introduction of the Bill of Rights, a number of bills were challenged, and of course, since the Charter of Rights and Freedoms, we have seen quite a bit. It presents extra challenges to those who draft these, but appropriately so. I remember in the mid-'80s, when I was a member of Parliament, part of our challenge was to just check on legislation that had already been in place. Now, never mind new pieces of legislation, just the legislation that was already on the books. Many, I shouldn't say many, but a fair number were found to have some constitutional deficiencies. And so part of the challenge that the Justice Committee faced was to deal with many pieces of legislation that were sort of updating Canada's laws to take into consideration that there were these other considerations that had to be met. Coupled with that was the assurance that whatever we tabled would meet constitutional challenge. I remember the bill in 1993 to make it a crime to possess child pornography. I mean, I'm sure in my office I had, comments, briefs, articles a foot thick, questioning whether this was going to meet a constitutional challenge. And as a member of the committee, it seemed to me, looking at that and having a look at the Charter of Rights, that in fact it probably would, that this was a very reasonable piece of legislation for the first time to make it an offense to possess child pornography. And but I was under no illusions. It was challenged, of course, on at least a couple of occasions, and there have been some changes to that legislation since, but it has managed to sort of stick-handle its way through the years and is still part of the law of this country. So not just me, but the people in the Department of Justice who are experts in this area, they take their responsibility very seriously. And so, yes, every piece of legislation that, every line, every clause, they draft these with a view to ensuring to the greatest extent possible that these will withstand constitutional challenge. But as I indicated to you, this is a right of individuals who are charged with or convicted of an offense to have the benefit of every law in this country. And I think most people say that the constitutional protections, and quite frankly, they predate both those two statutes that or two pieces of law that I indicated to you. I mean, you can go right back to the Magna Carta, and indeed, when I was in law school, I mean, the provisions for the writs of mandamus and habeas corpus, all those are constitutional protections. They're a part of the laws of this country, and I think most people would agree that the justice system that we have in this country is a good one, and that it has done a pretty good job of protecting the rights of Canadian citizens.
Thank you, Mr. Harris. 5-minute rounds. Mr. Lee.
Thank you. Mr. Minister, I want to ask a question that I think goes to one of the core charter issues in this legislation. I think it's the core issue, but and it goes something like this. By the way, thank you for not reading your speech word for word and dispensing with the repetition of the Tackling Violent Crime Act, which was getting a little bit Orwellian there for a while. But good decision. Good decision. You'll have to get a new speechwriter, though. Anyway, here is the issue, and it's fairly technical, but here it is. Does the right to remain silent is a principle of fundamental justice protected by the Charter? So the question is, does the right to remain silent extend through the trial phase and into the sentencing part of a trial? Okay,
which particular trial? Just a trial in first instance?
All trials. It certainly exists during the trial of an accused, the right to remain silent.
Exactly.
I'm just asking, does that right to remain silent for an accused exist during the sentencing part of a trial? Of the criminal procedure. That's just the opening question, and that's been confirmed by the courts in
case,
Bear and others, 1990. Okay. But if it does, then the existence of the presumption in this section of the new C27, which is your staff will know what I'm talking about. The existence of a presumption in 783 1.1 would seem to undermine the right of the accused to remain silent. I mean, if you foist upon an accused, a convicted person, a presumption, if you foist the presumption upon him or her, he or she has to rebut. They've then lost the right to silence. Now, if the answer is no, the right to silence, the right to remain silent doesn't exist after conviction, if it doesn't, then I would also put this question to you, that we are asking the convicted person to rebut, to prove a negative, i.e. that they're not dangerous. We're asking an individual who's just been convicted for the third time by way of a presumption foisted upon him or her to prove a negative, i.e. that they're not dangerous. And I don't think in Philosophy 101 anyone can be asked to prove a negative, because you can't prove a negative on balance of probabilities or on by any standard. So those are the three questions I would ask you. One, the right to remain silent before and or after conviction. And third, can you, under the Charter, foist upon a convicted person the need, by way of a presumption, to rebut a negative? And if you want to call me an advocate for convicted persons, I guess we'll have to do that. But that's my job. And Mr. Harris, that is our job here. We've got to actually charter test the thing before we squirt it out the end of the toothpaste tube. So that's my job. Anyway, there's the questions.
Well, starting at the beginning, well, thank you for your comments. I usually don't stick too closely to a prepared text, but I have to tell you, Mr. Lee, the people who do put these things together, in my opinion, do an excellent job. And I can tell you that I've been very well served by the background papers, the notes that I have received from them. Now, you then began to talk about the right of a person not to either testify or speak. I mean, it's based in the person's right to against self-incrimination. I mean, that's the basis of that. That you're not you don't have to say anything that might incriminate yourself. And go ahead.
I was just going to say, no, there is a distinction between the right of a person not to incriminate him or herself in giving evidence or in confessions, but the right to remain silent is a principle of fundamental justice. That's right. Standing on its own. And I'll stop there and let you continue.
But what we're saying, Mr. Lee, on this particular piece of legislation is that these are individuals who have been convicted. They're already before the court with 3 serious offenses for which they have been given conviction. And what we're indicating to them is that you better put something on the table to rebut the presumption that you are a dangerous offender. I mean, in a sense, we're at the sentencing stage of this, and you're right. An individual doesn't have to bring forward any evidence. They don't have to. They don't have to say a word. But I think it's clear, and I think it's fair enough that and we're talking about some of the most dangerous individuals in Canadian society. I mean, we're not. We're not talking about common assault here, and as you know, that list. So again, I think it's reasonable to, I'm sorry, we're running out of time.
Thank you,
okay,
Minister.
Thank you.
The staff to provide an answer to those questions. It's a technical thing, is if they they can't give it today, they'll have to come back. So while we can't have an answer now, it could be prepared in writing for later. Thank you.
Chapatis.
Merci beaucoup.
Thank you. Good afternoon, Mr. Minister. First of all, I'm very happy you were able to put all this legislation under C2. And I'd like to tell you about something that happened in the province of Quebec. There was a Mr. Boisvenu whose daughter was killed and who learned about a part of the bill and was very happy that this is something that will be helpful, because he's a member of an association that is made up of parents whose children have been killed by firearms and in other ways by repeat offenders. I'm also like to talk about a Mr. Melache whose son, Sébastien, was strangled to death by a sexual offender. And perhaps in the future we'll not have to see these things again. The third group that would like to thank you is, and I know that my colleague, Mr. Ménard, has studied the street gangs case, and I know that Madame Faye has written a book on this phenomenon. these are people who may kill simply because you're not wearing the right kind of color of clothing, or you're wearing the wrong color of clothing. And there's another group which might thank you. And in my personal practice, I've often had to deal with them. This is cases of diminished faculties or driving or acting under the influence. Now, these are people were involved in deaths from when people are impaired, where people are killed by impaired drivers, people who are impaired either from alcohol or drugs. And the question I'd like to put to you, Mr. Minister, is this. I'd like you to explain. I'd like you to explain why all these bills, which we found to left and right all over the place in the bill, why were they brought together under Bill C2? Why should Canadian citizens watching today want this to go forward quickly? What is the message you're trying to get across to them?
Thank you, for that question. You're quite correct that this bill covers a wide range of areas within the criminal code. I believe all of them are stand up for the rights of victims. I think they are a reasonable response to a number of different issues that have confronted us. I mean, these were certainly issues that we talked about in the last election that we would proceed with. You were asking me why did we put this together in one comprehensive piece of legislation, and I guess I'll begin by saying because we didn't get them passed in the spring and or the winter for that matter, and I think these are pieces of legislation that will be generally and for the most part welcomed by Canadians. They will want to see these the different components of this piece of legislation. They want to see it in place. I mean, I mentioned, I said in my opening comments that one of my favorites was the age of protection. It's long overdue in this country. I mean, we can argue about whether it should have got through in the spring or the summer, or I mean, I go so far as to say, like, I mean, it's a century overdue. I mean, that piece of legislation reflects the mores and some of the thoughts of the 19th century. The idea that, and it happens where a 40-year-old can be preying upon a 14-year-old and then, make the case or something that Canadian law doesn't cover this. It's wrong and it doesn't make sense to me, and I want to see it get passed. And so I'm hoping putting this together again, and I'd welcome. We could argue for another hour as to why it didn't get passed, I don't know, last spring, last summer, but I think this is a good way of profiling these issues. I think they have been thoroughly aired, and I'm hoping that this committee will move forward and say, look, these are reasonable items. They have been, all of them have been in the public arena for at least a year. I mean, all of them have been at least a year. And granted, we made some changes in response to a number of groups, including the Attorneys General, some amendments. But I'm hoping that this committee will move forward on this. And I truly believe that Canadians will thank us if we move forward and get this comprehensive piece of legislation passed. So thank you very much for your comments, and I appreciate your commitment to this.
Madam Freeman.
Bonjour, Monsieur le Ministre.
Good afternoon, Mr. Minister. I have a technical question to put, and I think it might be one of your officials who can answer. In Section 42.4, in 753, 4, and 4.1, so they say if the offender is designated a dangerous offender, well, they're talking about the following changes. If the court say this is a dangerous case, they can bring down a prison sentence, an indeterminate prison sentence, or a minimum sentence of 2 years, or they can bring down a sentence if he, another kind of sentence if he pleads guilty. Can you tell me what the purpose of this exercise is? Because it doesn't seem quite clear to me.
As the Minister's already stated, the broad scope of the reforms to the dangerous offender legislation is to respond to the case R versus Johnson. R versus Johnson, in fact, laid out a bit of a different landscape from which was there previously, in that it suggested that even though an individual meets the dangerous offender criteria, they still will not be designated dangerous offender nor receive the dangerous offender indeterminate sentence if, in fact, there's a finding by the court that a lesser sentence can manage the risk posed to the general public. So what these provisions do is kind of respond directly to the Johnson case by, number one, separating sentence from designation, and by basically the court first will determine that if they meet the criteria, they're designated as a dangerous offender and they're a dangerous offender for life. Once that occurs, then the court turns to the issue of the appropriate sentence, and the test is now emphatically laid out in accordance with the Johnson decision, whereby the court, if it's satisfied unless it's satisfied that the lesser sentence will manage the risk the offender poses of future offending, then they have to receive the indeterminate sentence. So what those two provisions do, subsection 4 now lays out the 3 sentence choices for the court, and section 4.1 sets out the Johnson test, the actual criteria there to apply whether or not to make the indeterminate sentence or the lesser sentence.
Je vous remercie de cette explication.
Thank you for the explanation. And there are other primary offenses. Why did they not add other offenses such as terrorism and killing someone when impaired?
It's always a judgment call. Madam Freeman, these are, I mean, for instance, it may be you that was asked, why not manslaughter? I mean, again, we're trying to get those individuals who set out, have the necessary mens rea, the necessary guilty mind to go out and deliberately commit a number of serious offenses. And that doesn't mean that other offenses aren't serious, but nonetheless, we've gathered together to make a reasonable package that would, I think, address those individuals that we would categorize as career criminals, the individuals who are prepared to do it over and over again, inflict violence or sexual assaults on others, and those are the individuals that we zeroed in on, and not people who or terrorism or treason or something else, unless it's comes within that definition. Is there anything you want to add on that, Mr. Hoover?
Just that one of the issues raised was how this compared to U.S. style legislation. Again, in U.S. style, there's 3 offenses that kind of automatically trigger a life sentence. This does not do that. This is designed very deliberately to narrow the scope towards the target individuals who typically are going to be subject to a dangerous offender application, and in many cases a successful one. This allows for a charter viable procedure whereby the Crown can in fact avoid a protracted, lengthy, and expensive hearing and basically go to the same result that they're going to anyways, which then leads to the real issue at the heart of these hearings since Johnson, which is what is the appropriate sentence to give an individual who has in fact met the criteria of 753(1).
Some of those individuals, to be fair, Adam Freeman, would already they'd get the life sentence in any case if you committed, premeditated murder. I mean, that's not who we're targeting here, particularly with this. They've already got the life sentence. So.
Alors, j'aurais une dernière question à vous poser.
I have a last question. When there's a supervision order,
so we'll have to wait for the next round. Mr. Keddy, 5 minutes.
Thank you, Mr. Chair. Thank you, Minister Nicholson, for appearing to committee today, your assistance. Certainly, I think this is a timely piece of legislation, and just listening to the discussion around the table on the, whether or not this infringes on the right to remain silent, the existence of presumption of guilt, a lot of legalese terms, if you will. My understanding here is that there's been, you know, some flaws, if you will, in the criminal code, and this is an attempt to address those flaws that Canadians have been asking this government, and they asked the previous government to address the inequities and the failures that are in the criminal code and bring in substantive changes. Certainly, I don't see this as any attempt in any way, shape, or form to subvert the Charter. But we do have this incidence out there where you use the word career criminals or recidivism amongst criminals who reoffend and repeat offend, and you know, and that's only one portion of this particular piece of legislation, but I think that's the portion that Canadians are extremely concerned about. And I'd just like maybe some of your further thoughts on that subject.
Well, I'm always prepared to give them, Mr. Keddy, and thank you very much for your comments, and thank you for being a member of this committee, and I appreciate your commitment to the issue of fighting crime in this country. I think what we're doing is a commendable exercise in our responsibility as legislators. I have sat where you have sat for many occasions with various pieces of legislation, and for the most part, throughout the 80s and the 90s, we gave usually we give guidelines to judges as to the seriousness with which we took the crime, and we usually did it in terms of maximum sentences. And I remember on a number of occasions where we revisited certain sections of the criminal code and say, look, that maximum sentence doesn't reflect the seriousness with which society views this type of behavior. Now, that was a legitimate exercise in our legislative responsibility. So too, putting minimum sentences, in my opinion, is a responsible exercise of our legislative responsibility, because what we're trying to do is we're just trying to give some guidance as to the seriousness with which Parliament views some of this activity. Now, you know, and I know some of the serious problems that have and can arise in this country with respect to firearms offenses and crimes that are committed with firearms, and you, as a representative of your constituents from Nova Scotia, you know how serious people take that and how upsetting people find that. And I think it's incumbent upon us to try and draft legislation to take into consideration these legitimate concerns of law-abiding people, at the same time recognizing the Charter and the rights under the Canadian Bill of Rights of individuals who are accused of a crime. And what we're trying to do is strike that reasonable balance. I'm convinced that we are doing that, and it, again, is a legitimate exercise of why we are sent here and what we are supposed to do. So I think all parliamentarians, and I hope I can say that when this bill gets passed, can take a lot of pride in getting these pieces of legislation. These is a substantial piece of legislation. As you know, this is the first bill introduced into this session. It's not just a coincidence that it's C2 and that it's all to put it all together, because these are steps in the right direction, and I appreciate the support of you and indeed the support of all committee members. And again, I wish you well in your deliberations, and again, hope this bill gets passed as expeditiously as possible.
Thank you, Mr. Minister. And we are now coming up to a vote, obviously. So what I would like to ask, we still have we started about actually about an hour ago, so we've probably about a minute and a half short of an hour. What I would like to ask, though, Mr. Lee, first one point that I did want to clarify, we are going to have staff back tomorrow for an hour. Your issue with respect to some of the technical questions, you may want to reiterate at that time to get that out. Whether or not that then requires anything in writing, I'm not sure, but at least offer you the opportunity to do that. The second is if we could just suspend for at least for the period of the vote, and then come back within about 15 minutes after the vote. One of the issues that we need...
we have some obligation.
You do? Okay. One of the issues that we need to deal with are, we need to, if we could then, if I could just ask before we leave, if we could at least have a list of priority witnesses, the top 4 or 5 that you would like to see. The reason I make the request is we are having some difficulties in terms of arranging for witnesses for the next 2 days. If there are priority witnesses that you would like to see here and you believe would be able to attend, we would appreciate getting that from each of the parties. It would allow us the opportunity to pursue them from here. And please, yes, get them to the clerk. Thank you.
Meeting adjourned. Meeting adjourned.
Meeting's adjourned.